Welcome to our How to Do Well in Business Law video. My name is Jerry Luligian. I'm going to walk you through a very good method of doing well in business law. It's important for you to follow this method because it probably varies from what you do in other classes, but it's very important to the concept of business law. In fact, it's applicable to any law class. And the reason this method is so important is that we will see when we get into the specifics of the method that the legal concepts themselves are pretty easy to understand once you've read the examples and the explanations, you've talked about them in class and so on. It's pretty easy to understand them, but you have to do more than simply understand the concepts to do well in any law class. We must be able to apply the concepts that we have learned to a given fact situation and come up with a correct legal analysis and conclusion to make the law useful to us as a business professional. What this means is that you will see fact situations coming up in your business life, and we would like you to be able to recognize legal concepts that sort of call out from those fact situations for you to analyze them to make sure that a law applies or could possibly apply to the situation. So you can call in an attorney to make sure you're properly guided through the legal process. We are not essentially trying to turn you into attorneys, but we are trying to turn you into someone who can recognize when the law will likely apply to a given set of fact situations that will come up before them on a daily basis, and be able to do something useful with that information, like calling an expert to make sure you're properly guided. Okay? So the problem that's facing students in any law class is not the ease of understanding each concept by themselves. It is the sheer number of legal concepts they will be responsible for applying correctly to a given fact situation. We will give you a fact situation, and you may have hundreds, possibly, of legal concepts to go through to figure out which one or more than one might apply to that fact situation in order for you to come to the correct legal result. So the solution here for you as a student and as a business professional is to outline each of your chapters with just the definitions of each legal concept. So you have a well-organized series of legal concepts and their definitions sitting before you. So when you go to a fact situation, or you do your written assignments in class, or you do your final exam in class, you can pull on the actual concepts themselves and their definitions and sort of comb through them to find the ones that apply to that situation. You can then apply them, and sometimes it's more than one, to come to the correct result. If you don't use this method, I can assure you that you'll be struggling with this process. I can also assure you that if you use this method, you will find it to be rather easy to do well in this law class and, for that matter, any law class. Okay, so the concept here is for you to just outline the definitions of each legal concept. You do not want to add in any additional explanations or examples into your outline. You do not want to basically put too much information into your outline, because all you need are these series of rules and their definitions in an organized fashion under different kinds of laws for you to be able to comb through them and when you're presented with a fact situation, so you know which laws will apply, because they'll just jump out at you right out of the page. If you didn't have this, you would have to be going back to the book to think about all the concepts that were there. It gets a little bit confusing, to say the least, and makes it very difficult for you to understand exactly what concepts will apply to that fact situation. So let me show you how to outline just very generally, and then I'm going to have you do that for all of your chapters. And then, as I say, I can guarantee you, you will find this course to be easy, and you will do well in this course if you follow this method. And again, you'll be struggling to do so if you don't. So let's take Chapter 10, which is the agreement elements of an enforceable contract, and we will show you how to create your outline. We're going to only go through part of the chapter. That chapter involves both offer and acceptance, two elements of an enforceable contract. We're going to go over only the portion on the word offer. So we're going to put the chapter up before you from the textbook, and then I'm going to show you how to outline. Okay, here's your textbook on section 10.2 of chapter 10. In this section, it's going to define for us what an offer is and give us some of the requirements for the offer beyond its normal definition. Now, if you look at the offer as it's defined here from the Restatement of Contracts, it's a little bit confusing. It says, the manifestation of willingness to enter into a bargain so made as to justify another person in understanding that his assent to that bargain is invited and will conclude it. It's a bit tough. If when you read all this stuff, you want to put this kind of information into your own words. So you're going to have to translate it into something that makes more sense to you, and these words don't do a very good job of it. So let's see how I've done that to show you how to do it. Now, here's how I have defined the word offer. It's words or conduct that, to a reasonable person, evidence a willingness to enter into a binding contract if the offeree says, I accept. Now, that's pretty easy to understand. So you can see by putting into my own words, I've made this much more easy to understand. This is perfectly accurate as to the actual definition, but it's just in words that make more sense. Now, by the way, I put red over here, the to a reasonable person, because when we do our work on the initial part of a contract, we knew that that contracts are always interpreted from a reasonable person's standpoint rather than based on subjective intent. And so the words or conduct have to be judged to a reasonable person rather than based on what subjective intent there may have been by the person who was making the words or the conduct that we say may have been an offer. Okay. Now, part of the chapter also talks about additional things that are necessary for the offer. Let's take a look at those. The offer has to have certain things in it in order for it to be considered a valid offer. Certainly, the offer must be objectively, or at least evidence of objective intent to be bound, as we just said already, so we don't have to put that one in again. But the terms of the offer must be definite or reasonably certain, and we'll see in a minute what that means. And the offer must be communicated to the offeree. If you don't communicate your offer to the offeree, it has no effect whatsoever. So let's look at what the meaning of definite or reasonably certain is. To be considered definite, an offer generally must contain the terms as follows. One is the identification of the parties. Number two, the identification of the subject matter and quantity, if that's applicable. Consideration to be paid in the time of performance. So let's take a look very quickly at what that looks like in my outline. Okay, so I put here, offer requires the following. Terms of the offer must be sufficiently definite or reasonable. The offer must be communicated to the offeree. Remember, I already have the reasonable person standard up here, so I don't have to have that third one here that we saw in the book. And then I now are going to define sufficiently definite. In order to be considered sufficiently definite, the offer must contain the identification of the parties, the identification of the subject matter and quantity if applicable. Consideration to be paid in time for performance. Okay. Now, there's additional things about offers that we also need to know that are in our chapter that we want to put in our outline. Okay, first there are what we call special offers. These are ones that we want you to look at because they need special treatment, or you need to understand them specifically because they either do or do not constitute offers, or there's certain special rules about them that we need to know. First, advertisements are generally not treated as offers. If you hear someone advertising a car model for sale at a used car lot, or even better at a new car lot where they may have any number of those cars available to sell, that is not considered an offer. You can't go in there and say, well, you said you were going to sell the car for $20,000. Here's $20,000. I want the car. No. There's many reasons for that, by the way. And one of those reasons is that we wouldn't allow advertising at all if they had to come up with any number of those items at that price, no matter what. And the reason for that, of course, is that you're putting advertisements out to the world. If everyone in the world came through and said they wanted one of those cars, they couldn't do it, and they couldn't do it at that price. But in order to make sure that is the way it happens, the law has decided that, generally speaking, advertisements are treated as an invitation to make an offer. That means invitation to come on in and start bargaining. Okay, but there is an exception. If the advertisement is so definite, so specific, usually to a very specific item and very specific price, and even talks about maybe, the first one to come down and plunk down $20,000 gets this car with a certain license number, a certain VIN number, then the advertisement will be considered an offer. Then you can go down and accept it. Okay. And rewards. An offer to pay a reward, usually for lost property or for to capture a criminal. That's what we say is an offer to form a unilateral contract. And so the offeree must first have knowledge of the reward prior to completing the requested act, and then they must perform the requested act in order to actually accept the offer. You can't do anything about accepting the offer until you actually perform the act. That's necessary for rewards. In auctions, what you need to know is an auction is really an invitation to make offers. At least an auction with reserve is. That means that the auctioneer will throw out numbers and say, is anyone willing to offer $10,000 for this item? And they'll get an offer. When the gavel falls, that is acceptance. Now, an auction without reserve, though, has a special rule, and that is that the seller must sell at the highest bid unless there is a minimum bid that's been specified. They cannot withdraw the goods from sale like they could terminate an offer before acceptance. Okay, let's see what that now looks like in our outline. Again, special offers, advertisements, rewards, and auctions. Advertisements generally are considered to be invitations to make an offer, but not an offer by themselves. And then I put down the exception. When an advertisement is so definite and specific that it is apparent that the advertiser intends to be bound to the terms of the advertisement, then we have an offer. Now, I want you to see this format here. I have a rule regarding advertisements, and I have an exception to the rule. It's a very good idea, whenever you have exceptions to rules, that you place them indented underneath the rule itself. The general rule should be stated as a general rule, and exceptions placed underneath it. The reason for this is that you want to be able to see those exceptions at the time that you're looking at a fact situation, because one or more of those exceptions may be there, and you don't want to be applying the general rule without realizing that there are exceptions. Okay, number 2, rewards. To collect, the offeree must first have knowledge of the reward offer and perform the act requested in the offer. That's all you need to know about rewards. Auctions. Auctions with reserve is an invitation to make offers. Auctions without reserve requires sale at the highest bid unless there's a minimum bid announced. That's all you need to know about auctions. Okay, one more section on offers has to do with terminating an offer. We'll see what that looks like in the book. There's several ways that an offer can end up being terminated. First, it can be revoked by the offeror if it's revoked before its acceptance. It can be simply rejected by the offeree, in which case it's terminated. It can also be rejected by a counter offer. If an offeree makes a counter offer to an offer, it automatically terminates the offer and creates a new offer. Okay. Now, there's also different kinds of rejections, such as by operation of law. First would be the destruction of the subject matter. If the subject matter is destroyed through no fault of either party before there's acceptance, then the offer terminates. If there's a death or incompetency of the offeror or the offeree before acceptance, it terminates the offer. If there's what we call supervening illegality, what that means is that at the time an offer is made, the offer is dealing with a legal subject matter. Before there is acceptance, however, the subject matter of the offer turns illegal. If that happens, it automatically terminates the offer before acceptance. And last is the lapse of time. In essence, a certain amount of time goes by, no response to an offer, it will terminate on its own terms, or just by being around for a reasonable time. So if there is no time in the offer that limits the time for an acceptance, then when a reasonable time has gone by, and that's up to a court to decide, then it'll terminate the offer. If there is a time specified in the offer that limits the time in which an acceptance can be made, then that will be the limit for when an offer can be accepted, because afterwards it terminates by its own terms. Okay, let's see what that looks like in our outline. Okay, and I put down revocation of an offer. It's probably better to put termination of an offer because it can be either revoked or terminated by operation of law. Anyway, first one is revocation by the offeror. Next is rejection by the offeree. Next is rejection by counter offer. Next is destruction of the subject matter. We've already gone over what that rule is. Supervening illegality, we've done that rule as well, and lapse of time. So now you have all these definitions sitting here. You have a full and complete list of every concept having to do with offer that you will be responsible for in this class. All right, so I hope this helps to understand how to do an outline and what you're supposed to be doing in the outline. And you'll be able to see the first time you use that outline to help you on your written assignment, on your discussion questions, or certainly when you do your final exam. You're going to see how useful this is to making your life so much better in terms of doing well in a business law class, or for that matter, in any law class. So if you'd like to have more information on outlining for a law class, please be sure to talk to your professor and get some tips from your professor about how to do this in the particular way that they think is best.